did you enter the U.S. without inspection, without parole, and now you are married to a U.S. citizen or a permanent resident that has filed an I-130 for you, or your parent that's a U.S. citizen filed an I-130 for you, and now it's time for you to apply for the visa. Oh, but you entered without inspection. What do? Well, you can apply for an I-601A waiver, and that can lead to you being able to go to your interview at the embassy and be able to come back to the U.S. without having to trigger the 10-year or the 3-year bar. I am U.S. Immigration Attorney Lilian Chukwurah, and I help my clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. The 601 waiver is one of those things that is part of immigration law. The law says that if you have a U.S. citizen or permanent resident parent or spouse that will suffer extreme hardship if you were not allowed to remain in the U.S., or if they had to go with you and live in your country of origin, you can then apply for the 601 waiver. The 601A waiver only waives the fact that you were unlawfully present in the U.S. So the 601A waiver is a complex process. And the reason it's a complex process is because you have to look at the full picture of the person applying for it, right? It only waives unlawful presence in the U.S. It does not waive anything else. So our first step usually is to figure out if the person has any other things that make them inadmissible. So when you're applying for permanent residency, the U.S. government looks at your entire background to see if there's something in there that's against the immigration laws that make you inadmissible, meaning you are not able to get this permanent residency. There are some things that if you are inadmissible for, you can apply for a waiver. Unlawful presence in the U.S. is one of those things, and the waiver is the I-601A waiver. However, if the person also has a misrepresentation, either they presented a false document or told a falsehood to USCIS or to the embassy when they were getting their visa, or whatever it may be, right? If they have misrepresentation plus unlawful presence, the 601A waiver will only waive the unlawful presence. You will still need a 601 waiver for that misrepresentation, right? So it's always looking at what do you actually need before you even start. So it is very complex. You want to make sure you're following, doing things in the right order, right? You want to make sure that you're doing things in the right order so that you do not mess up your case and end up triggering the bars that the 601A waiver is supposed to waive, right? The purpose of the 601A waiver is that if you're in the U.S. unlawfully, and you have been in the U.S. unlawfully for 6 months or more, but less than a year, and you leave the U.S., you will trigger a 3-year bar, meaning you're not able to get a visa to the U.S., including an immigrant visa to the U.S. for 3 years, okay? If you've been in the U.S. for a year or more and you leave the U.S., you will trigger a 10-year bar. However, if you have an I-601A waiver already approved, and you leave the U.S. for your visa interview, go to your interview, get approved at that, you can come back to the U.S. and never trigger that bar because you already had it waived, right? You already had your unlawful presence waived. Now, if you do things in the wrong order and leave the U.S. before your waiver is approved, you're going to trigger that bar. So then you'll need to either remain outside of the U.S., away from your family, for 3 years or 10 years, or apply for an I-601 waiver to waive your unlawful presence and that 10-year bar. So doing things in the right order is really important with this waiver. The first thing you want to know, once you know that you need a 601A waiver, the first thing you need to do is go ahead and file your I-130. Okay, before you can get to an I-601A waiver, you need to have an I-130 approved. If your I-130 is not approved yet, you cannot start with a 601A waiver. I know you want to file everything at the same time, but the way U.S. immigration law has set it up is a one thing at a time. So you start with the I-130, get that approved. The case is then sent over to the National Visa Center, where you will pay your visa fee, the affidavit of support fee, and get evidence that you paid those fees with evidence that your I-130 was approved in order to file your I-601A waiver. You cannot file it without those two things: proof of payment of the visa fee and proof that your I-130 has been approved. Those two things are needed and necessary before you can get to the I-601A waiver. So that's the first thing you want to make sure you have. While your I-130 is pending, though, you can start getting your documentation together for the waiver. So the waiver, the form is Form I-601A, right? That's the form you fill out. But as far as documentation, you're going to be looking at your relative, right? Is it your spouse or your parent? What is the hardship that they are going through? What does that look like? Are you the only person working in your family? What is the financial burden that will be on them if you were not in the U.S. anymore? Do they have medical conditions that make it impossible for them to travel with you? You need to document these things. If you're saying there's a financial hardship that will result in you having to leave the U.S., document that, right? What's the bills, right? How much expenses do you have every month? How much income? What will happen if your income is all of a sudden taken out of the equation? How would your household survive? If you have children, would your spouse be able to work and care for the children, right? Would they be able to afford it? Because it's not just, yes, they can put the child in daycare, but how many hours a week do they now have to work extra to then be able to not only afford to work, be able to afford the household expenses, be able to afford putting the children in daycare? All those things matter, okay? All those things matter. The same thing for your parents. If your parents live with you, what will happen to them if you're no longer here? Who will care for them? How will they get their day-to-day needs met? So you're looking at the practical, everyday need of the person. And then also the fanciful things of what is their future going to look like if they had to move back to your home country with you? If they are, let's say, in school for a specific degree, would they be able to go over there and do the same thing, right? Would they be able to get employment? Do they even speak the language? Those are all the things that we kind of get documentation around to show the hardship that will result if your spouse or your parent has to leave with you. It's really important that when you're looking at hardship, especially to a spouse where children are involved, the children on their own, like I said, do not qualify as the qualifying relative for the waiver. But guess what? Your spouse will suffer hardship if their children are suffering hardship, right? I know me. If my kids are not able to get the education that they deserve, if they're not able to get the medical treatment that they deserve, that they can easily get in the U.S. because now we have to move to another country, that is going to hurt me, right? I will be worried about my children and their future. So don't just think about it from how, the U.S. citizen spouse or parent. Think about it from, yes, how will this other issue affect the U.S. citizen spouse or parent, right? How will you having to leave the U.S. with your kids affect your parent? Because they have built this bond with their grandchildren, and now they no longer are going to have that relationship, right? They're no longer going to be able to have that time with their grandchildren, be a part of their day-to-day life. They're now going to be worrying about their safety, their education, all of those things, right? So it's really important that as you're looking at these things, you're looking at the full picture of the person, not just, oh, okay, medical, right? When we talk about it, we really dig deep to figure out all the different things that can affect the person, all the different things that can lead to extreme hardship. Another thing that we do is recommend a psychological evaluation. Again, I'm not a psychologist. There are people, they are qualified to really talk to the person get a detailed background, figure out what is going on up here. How will this change in the family dynamics affect the person? Right? Do they have a history of depression? How will this separation trigger that depression? How will it affect their day-to-day life? That's really what you want to really put in there. We do a statement from both sides, so the qualifying relative and the person applying for the visa, because again, you want to show your family dynamics, you want to show all of that. Your statement, there's no length that it needs to be. I know people really want like, oh, it should be like at least 5 pages. No, it needs to show what the hardship is, right? Your statement does not need to be 10 pages. It does not need to be, 15 pages. It needs to be as long as it takes for you to convey to an officer what the hardship is, what the relationship between you and the qualifying relative is. What is the hardship that that qualifying relative will have? That's the thing that your statement needs to show. It's not show, put your emotions on the page. Put the practical things on the page. Because sometimes people forget about the practical day-to-day. And they just talk about the dreams and the goals and all of that. No, but what about your practical day-to-day? How is your day-to-day going to change? That's really what we try to put together in those statements. Our role as your attorney is to help you put together a strong 601A waiver by making sure you have the right documentation, right? Making sure that your statement is strong and conveys that hardship. Making sure that you know all the things that can lead to hardship, all the things that you can produce. Having those conversations with you. Because sometimes you don't consider something a hardship until someone points it out to you, right? How are you going to drive your kids to school when your spouse is the one that always does it? Because you have to be at work at 7 a.m. and the kids have to be at school at the bus at 8 a.m. Who's going to take care of that for you, right? So we kind of try to call all of those things out so that we can get you the best possible package for your 601A. Now, let's talk about what happens after you submit your application. Once you submit the application for the I-601A waiver, you're going to get a biometrics notice. Basically, you need to go get fingerprinted. USCIS will do a background check on you. That's the purpose of that. And then you wait. Unfortunately, this process right now is taking about 3 to 4 years just for the waiver. Remember, you need to get your I-130 approved first, which right now is taking about a year to a year and a half. So once that is approved, then you can move on to the 601A waiver, which has its own waiting period. It has its own processing time. So once that is approved, then you can move forward to completing your visa application, completing your affidavit of support, getting your interview scheduled, and going to your interview. It's really important that as your process is going on, you as the non-U.S. citizen, you that's trying to get that visa to come back to the U.S. and be with your family, that you do not do anything that can jeopardize your case. Okay? Don't do anything that will jeopardize your case. Don't get too close to any U.S. borders that you may accidentally cross the border. Because anytime you cross a U.S. border into another country, you just triggered that bar that we're trying to get a waiver for, right? Do not get any criminal records in the meantime, because guess what? Now, your 601A waiver is only going to waive your unlawful presence, does not do anything for the criminal bar, because you'll need a different waiver for that, or you may not even have a waiver available for that. So it's really important that as your process is going on, that you're keeping your attorney updated on every single thing that's going on, to just make sure and verify that it's not going to affect your 601A waiver. But yeah, this is the process for getting a 601A waiver. Like I said, the main thing that you need to really pay attention to is that extreme hardship, right? And knowing that the only people that qualify as your qualifying relative for the waiver is your U.S. citizen or permanent resident, spouse, or parent. No one else. So In the next videos, we will kind of go through the pitfalls to avoid, and also give you some tips, additional tips on having a successful application. So stay tuned for those. If you would like to get some help in getting through the 601A waiver, figuring out if you qualify for it, if you have enough in there to show the hardship, feel free to schedule a strategy session with me. You can do that by going to my website, lilylegal.com, and clicking on Contact Us. That way you can pick a date and time that works best for you for us to chat. If you don't like the internet and you want to call us, you can do that at 508-443-1788.